here? Okay. I'm not number 4 or 5. No. We talked about 4. Sorry, y'all. You took my disgruntled fire.
Zach, just let me know we're starting.
Right. Let's see. Is Mr. Youngblood here?
Family's not in the back today?
All right. Are you Mr. Alvarado?
Yes, Sean.
All right. I don't see Mr. Youngblood on the line. Mr. Adler, are you available to help? Mr. Berger, are you available to help? All right. Okay.
Judge, I did want to let you know that the victim's family is participating via Zoom. Tiffany Perkins.
All right. Thank you, sir.
Sir.
All right. Mr. Alvarado, this is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention, you must see a judge within 48 hours. And then if you're detained, see a judge every 10 business days thereafter. This is your 10-day detention hearing. I understand that you've been level 1-0 in the back since August 17th. You're currently being detained on a charge of murder, and there is a certification hearing scheduled for September 24th of this year. Mr. Berger, I'm appointing you to represent Mr. Alvarado for the purposes of this detention hearing, just instead of Mr. Youngblood. Mr. Berger, what are your thoughts?
Obviously, Judge, I don't have any information as to any of the facts of this case, so I would defer to the court on any decision.
All right. Mr. Alvarado, given the gravity of the charge and the allegation, given the fact that you've only been level 1-0 since 8/17, the court at this time is not convinced that if you were to be released, you would not be a danger to yourself or to the community, and therefore the court will order that you be detained, and that is the order of the court. Thank you, sir. Thank you, Mr. Berger.
Ron, I believe you're mute.
Porter, your mic is muted.
Oh, thank y'all. Sorry about that. All right, let me start over. Good morning, Ms. Alvarez Goodrich. My name is Judge Porter. The law says when you are brought into detention, you must see a judge within 48 hours. This is your initial detention hearing. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. It'll also get the attention of your attorney, Mr. Berger, who is here. I see, okay. I'll create a private internet chat room for you and Mr. Berger to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense, Ms. Alvarez Goodrich? Okay. Before Mr. Berger says it, I will advise you strongly, just don't say anything right now. Let Mr. Berger and Mr. Howard talk. Mr. Howard, the court is aware that the respondent was brought in on a charge of family violence. Reportedly last night, she got into a fight with her mother that resulted in mom being scratched, and mom complained that the touching was offensive. The court is aware of additional information regarding Ms. Alvarez Goodrich based on the court's previous hearings. Mr. Howard, is it appropriate for us to make a referral to CPS?
Yes, it would be, despite the situation. We're running out of options at the same time, Your Honor. We had multiple different programs that she's been in, so this is a continuous thing.
Mr. Berger?
Judge, I spoke with my client this morning. She is very determined that she does not want to return to the home. There are some family members that she would like to be considered, in particular her paternal grandfather, but I don't know about the suitability of that home or if he is in fact willing, paternal grandmother willing to accept her into the home at this time.
All right. For right now, Ms. Alvarez Goodrich, I will find that there's probable cause to believe that you have engaged in delinquent conduct. And I will order that you be detained. Mr. Berger, I will give you, take as much time as you need or as little time as you possibly can to investigate those alternative family placements, and then schedule another detention hearing earlier than a 10-day detention hearing, and the court can take up the issue of releasing those releasing Ms. Alvarez Goodrich to a suitable alternative family member.
I'll do that, Judge.
All right, that'll be the order of the court. All right, are you Mr. Bonilla?
Yes, sir.
Mr. Bonilla, my name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention and detained, you have to see a judge every 10 business days. This is your 10-day detention hearing. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. It'll also get the attention of your attorney, Mr. Adler. I'll create a private internet chat room for you and Mr. Adler to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
All right, Ms. Guerrero, what brings Mr. Bonilla back to court?
Yes, Judge, this is a 10-day detention hearing. He's scheduled for court for the 28th, but we also have an evaluation scheduled for the 18th of September. I don't know how much you want me to give you in reference to the offense due to the nature of the offense.
Let's see. No, the court is aware of the underlying allegation. And Judge Kim has already determined probable cause in that. He's level 2 acceptable in the back.
Yes, Judge.
Okay. Mr. Bonilla, did you and Judge Kim go over the levels in the back? Uh-oh, is he frozen? Mr. Bonilla?
Yes,
Hear
sir.
me?
Yes.
Did you and Judge Kim go over the levels in the back?
I don't think so.
Let me tell him in Spanish, Judge.
Oh, okay. Thank you, Ms. Guerrero.
Rafael,
Sí.
¿te acuerdas que el juez te dijo sobre tus niveles en la detención que necesitaban que hacer? ¿Te acuerdas de los niveles?
No.
Ahorita estás en qué nivel?
2A.
Perdón.
2A.
Ajá.
¿Y qué te dijo el juez? La única manera que te permite ir a la casa es si estás en qué nivel.
1O.
Oh.
Sí, y no
Ajá.
estás. No
Sí,
estás
es verdad.
ahorita. ¿Entiendes?
Sí.
Okay. Entonces, what do I have to do?
Entonces, ¿qué necesita que hacer el juez hoy?
Detenerme.
Sí.
Detain him.
Gracias, señor. That will be the
Gracias,
order.
Rafael.
Fowler, come on up.
All right. Are you Mr. De Leon?
Yes, sir.
All right, Mr. De Leon. My name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention, you must see a judge every 10 business days. This is your 10-day detention hearing. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. It will also get the attention of your attorney, Mr. Adler. I'll create a private internet chat room for you and Mr. Adler to talk about what you want to say. That way he can advise you on whether or not you really should say it. Anything you say at this hearing cannot be used at an adjudication or disposition hearing, but it could be used against you at a future detention hearing. Ms. Rojas, what brings Mr. De Leon to court today?
Your Honor, it's a 10-day detention hearing. He was initially referred in custody for unlawful carrying of a weapon and failure to ID. That was on the 5th by the Richland Hills Police Department. It's according to the offense report on the 4th at approximately 20:35 hours, officers were dispatched to Hanley Etterville Road in reference to kids shooting fireworks. Once they arrived, they made contact with 3 subjects. Angel was one of those subjects. After they spoke with them, they admitted to shooting the fireworks, and Traylon Jones admitted to having the fireworks in his backpack. Upon a probable cause search, Angel admitted to having a firearm in his waistband. A 9mm semi-auto with 4 mag was located. The gun was not found to be reported stolen.
Was or was not?
Was not.
Okay.
Through TCIC. And then when they asked Angel for his name, he gave the name of Alex Gabriel. And he was arrested at that time, transported to our juvenile detention center. A petition has been filed, and we're scheduled to go to court on the 26th of this month. He's also pending with Dallas County. He has a assault BI and an evading arrest offense in Dallas County. And he's also scheduled to be in court on the 26th. I talked to the assigned probation officer in Dallas County, and they don't want to put a hold on him yet. And they're just are indicating that if he's released here, then he'll have to appear there, and more than likely he'll be detained in Dallas County pending those other charges there.
All right, Mr. Adler, what are your thoughts?
Judge, the mother would like him to go home. The more serious charges in our county, and really I'm thinking I'm going to have to pass the case so I can try and take care of both cases all at once if I can. So I would ask that he be released to his mom on the electronic monitor. And Judge, it's my understanding she's ready for him to come home.
All right.
And your Honor, mom is, yes, she is on Zoom. Nora Espino, blue shirt.
Ms. Espino, are you ready for Mr. De Leon to come home?
I'm going to translate for you, Your Honor.
Sure.
Señora Espino, ¿ya está lista para que regrese Ángela a su casa? Did she freeze? Señora Espino, ¿puede oírnos? She looks frozen.
Yes.
But I did talk to her, and she is ready for him to come home.
All right. He's been level 1-0
since the 17th.
Correct. And he has no prior referrals to this department?
Not to our department, Your Honor.
All right. I will authorize his release on the electronic monitor. And Mr. Adler, I'll let you present any request for continuance from his current setting here in Tarrant County. All right, that'll be the order of the court. Thank you.
Thank you, Your Honor.
Is mom in the building, or is this a delayed release?
It's going to be a delayed release.
Copy that.
Thank you.
Release on EM, delayed release.
Okay.
Yes. Well, you got to get EM first, and then we'll take it back. Yes.
Señora Espino, el niño va a salir. Ahorita le llamo por teléfono.
Ms. Rojas?
Yes.
Mom was indicating she cannot hear you.
Okay, I'm gonna go ahead and call her and go sign out the paperwork for Angel.
All right, thank you.
Thank you.
All right, are you Mr. Fowler?
Yes, sir.
Mr. Fowler, my name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention, you must see a judge within 48 hours. And if you're detained, you need to see a judge every 10 business days thereafter. This is your 10-day detention hearing. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Move your hand back and forth like this. I'll create a private internet chat room for you and your attorney to talk about what you want to say. That way your attorney can advise you on whether or not you really should say it. I know Mr. Lofton is here in the building.
And Your Honor, we also have mom and dad as well.
Okay. I know Mr. Lofton is in the building. you go? Yeah. We're going to take just a second. The bailiff's going to go look for Mr. Lofton.
Hello.
All right. Okay. So,
Can you see me, Your Honor? I'm here. I'm present. I'm in the courtroom, courthouse.
So, Mr. Bell.
Yes, sir.
I understand that Mr. Fowler has fallen to level 2. What, other than that, what brings him to court today?
This is a 10-day detention hearing, Your Honor. He was referred on August 5th by the Fort Worth Police Department for aggravated robbery. He met up with some other individuals. The victim was basically summoned by Snapchat, asked to meet behind a auto zone where he was told that they were going to take his belongings from him. There were 2 other accomplices involved. They formed a little half circle around the victim. Victim was able to get away, went to his home, and Fort Worth Police Department went to the scene. Victim did leave his bike and his phone there as he was running away. Officer found those belongings and took them back to the victim. The victim identified Ford in a lineup on or about July 24th. And he was arrested at his home without incident on August 5th and brought here to the detention center.
Right. And the alleged weapon was a knife, not a handgun, correct?
Yes, sir. It's pocket knife.
And he has been, let's see, level 2-0 since the 17th?
Yes, sir. By our mathematics, he's supposed to be level 1 tomorrow.
Okay. Mr. Lofton.
Yeah, please, the court, Your Honor. I believe, I don't think there's any assertions that this individual had the weapon, that this individual did anything. He was, I mean, I think he was present, but I don't think if you're doing culpability, he was there. I mean, he was, he did anything or took anything or held anything up. And we would ask that if he's makes level 1 by tomorrow, that he be released on a monitor. His family is here today, and we're hoping to start school with the Keller Independent School District. We think on Tuesday or Wednesday, but that depends as our courts, Keller changes too, so.
All right. Give me just a second. Mr. Bell, do we have the results of his hair follicle drug test back?
Yes, sir. As a matter of fact, it took place on the 11th. We got it back a couple of days later, and he was clean on everything.
Hey, that made Mom and Dad real happy. All right, Mom and Dad, I am as shocked as you are, but I'm as happy as y'all are. So talk to me.
I mean, my understanding is, Judge, this is a detainment hearing, and that's what we're talking about. And in the conversations with Ford when he's called home and everything, I'm inspired to hear some of the things he's saying. He understands he needs to get his act together and has expressed the desire to get on that track when he gets home. So we're anxious to get him home and start working on that. And that's our desire, is to get him there so we can start that process and get him on the right track. But he's this isn't our first rodeo with different things with him. And I feel like he's sincerely saying that he wants to try and get on the right track, and we're anxious to get him home and start that.
Now, do y'all recall his last detention hearing with Judge Kim?
Yes.
What were your thoughts on the way Mr. Fowler talked? And I'm not talking about Dad, I'm talking about Ford. What were your feelings or what was your assessment about the way Ford talked to Judge Kim? Was it appropriate?
I don't recall really. I mean, there wasn't much said by Ford on that call.
Okay.
I don't think he talked
I don't recall either, Judge, and I'd have to ask Judge Kim if I don't.
Okay.
I've got other ones I can easily recall, but I've got, sure.
I don't think he spoke that day.
If he did, it was very short.
Okay. Okay.
Mr. Bell, is there something that you can?
Your Honor, I don't have any recall of if Ford did say anything, it was quite minimal. And I never noticed a time when he was inappropriate.
Okay. Okay. Mr. Fowler, I'm going to order that you be detained today because you're not level 1-0. All right. Once you get to level 1-0, I will authorize your release to your mom and dad. Okay.
Thank you, sir.
All right. That'll be the order of the court.
We have excused, Your Honor.
Thank you, Mr. Lofton.
Thank you, sir.
Thank you very much.
Mm-hmm. And that was transfer retained, so there's no pay slip. All right. Okay. Are you Mr. Riddle?
Yes, sir.
Mr. Riddle, my name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention, you must see a judge within 48 hours, and if you're detained, see a judge every 10 business days thereafter. This is your 10-day detention hearing. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. It will also get your attorney's attention. Mr. Graham, I'll create a private internet chat room for you and Mr. Graham to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
Anything you say at a detention hearing cannot be used at an adjudication or disposition hearing, but it could be used against you at a future detention hearing. Ms. Rodriguez, what brings Mr. Riddle back to court?
Your Honor, I'm covering for Ms. Rodriguez today.
All right. Thank you, Ms. Turner-Hill.
He's actually a companion to Mr. Fowler, who just went. He was not the person identified as the one with the pocket knife. And he is level 1 outstanding, and a petition has not been filed on his case, and his hair follicle test showed that he was only positive for THC, which was also what he was positive for whenever they did a UA, whenever he came into detention.
Does he have a parent or guardian here today?
Yes, sir, his mother's here.
All right. Does he have any prior referrals to the department?
No, sir.
Mom and dad, what are your thoughts?
Well, this is brother. Dad was not able to be here today. We'd like him to come home, obviously.
Have you had a chance to talk to him since he's been in detention?
Yes, sir.
How have those phone conversations gone?
Good. The past 5 conversations have been really good. It seems he has really had a change of heart.
And if I were to release him today, can you assure the court that you can get him back to court when he's supposed to be here?
Yes.
All right. If I authorize his release and he does not come back to court, 2 bad things happen. The first bad thing concerns Mr. Riddle. I will issue what we call a directive to apprehend, shortened to DTA. It's kind of like an arrest warrant for him. It will result in him eventually being brought back to detention. That's the first bad thing. The second bad thing concerns you, Mom. If he doesn't, because I'm releasing him to you, and I'm going to go ahead and authorize his release on an electronic monitor. If I release him to you, you're responsible for bringing him back. And if he doesn't come back to court, I could issue an arrest warrant for you that results in you being taken to the Tarrant County Jail and being held.
Mm-hmm.
Now, knowing all of that, if he doesn't come back to court, you could go to jail. You still want his release?
Yes.
All right. I will release him on the electronic monitor. Mr. Riddle.
Yes, sir.
You have been maintained level 1-0 in the back. basically since the 8th. That's a good long time. I expect you to maintain level 1O at home with your mom.
Yes, Your Honor.
Mom, if he doesn't maintain level 1 outstanding behavior with you at home, you pick up the phone and you call either Ms. Rodriguez or Ms. Turner Hill, and we will arrange for a meeting with me to address that issue.
I will not hesitate.
All right. Mr. Riddle.
Yes, sir.
You and your mom and I, we're working together. Between the two of us, you're not going to outsmart us or outthink us, okay? So it's just as easy for you to obey her rules at home, because the consequences of not obeying her rules are much worse with me than they are with her. All right?
Yes, Your Honor.
That'll be the order of the court. Good luck, Mr. Riddle.
All right. You have a great day.
Thank you, sir. Thank you, Mom.
Thank you.
Glad I could help, Your Honor.
Thank you, Mr. Graham.
See you, Judge. Thanks.
Your Honor, I'm covering this next one for Mr. Crawl, who was finishing up a hearing in Judge Terry's court.
All right. Thank you, Mr. Ansley. Mr. Berger, do you mind helping us out with the next hearing?
I'm good, Judge.
All right. Are you Mr. Turner?
Yes, sir.
All right, Mr. Turner, my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. If you're detained, the law says you must see a judge every 10 business days thereafter. Today's hearing is your initial detention hearing to determine whether you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. That will also get your attorney's attention. I'm appointing Mike Berger to represent you as your attorney during this detention hearing. Do you see Mr. Berger on the screen? He has a pink shirt and he's waving his hand.
Okay.
Do you see Mr. Turner?
No.
Mike, go ahead and say something.
Okay, Mr. Turner, can you see me? Still
Just
not?
keep talking.
We don't see him.
You can't see me?
Oh. Yeah, I see him now.
All right. If there's something you want to say, Mr. Turner, I'll create a private internet chat room for you and Mr. Berger to talk about what you want to say. That way he can advise you on whether or not you really should say it. Anything you say at this hearing cannot be used against you at an adjudication or disposition hearing, but it could be used against you at a future detention hearing. Now, Mr. Ansley, what brings Mr. Turner to court today?
Yes, Your Honor, and as you saw, his mother, Ms. Johnson, joined us during your admonishment. Your Honor, we don't have a lot of information. The short of it is he was picked up in Fort Worth by Fort Worth PD for a warrant out of Kansas. We know that the warrant involves 3 felony drug charges from Kansas City, Kansas. The warrant was signed August 8th. The date of the alleged offenses are from, let's see, January. There's 3 different dates: January 21st, 22nd, and 30th. I know Mr. Crawl has been in conversation with the authorities up in Kansas as far as extradition and such. But we've not really had a chance to talk to Charles or Mom to get much information from them. It appears we have a Dallas address for Mom currently. So I don't know what he was doing in Fort Worth.
Well, we stay in Fort Worth now.
Okay.
All right. Then that changes the tenor of this conversation. Mr. Turner, because this is an out-of-state warrant and it's not for any alleged violation of Texas law, then I have to let you know about certain rights. You have the right to contest your extradition to the state of Kansas. If you wish to do that, then you and Mr. Berger need to get together and let the court know about that, because there's a certain procedure that we have to go through. Our office here in Texas has to send information to Kansas, and then Kansas has to send us back certain information. Okay. The only thing you can contest at that point would be whether you are in fact the same person who is wanted by the state of Kansas. That is your first option. Your second option is to say, I'm not going to contest my extradition to Kansas. I'm actually going to agree to go back to Kansas and face those charges. Mr. Berger, on behalf of Mr. Turner, what are your thoughts about that situation?
Judge, I would like just a minute to speak with Mr. Turner to get some basic information.
That's appropriate. Please do make it brief because we've got some other detention hearings, but let me, give me just a second. I'll create that breakout room for y'all.
Thank
you. Oops. Give me just a minute, y'all. All right. Mr. Berger and Mr. Turner, y'all should be receiving the invitation to go into breakout room number 1.
And Your Honor, I apologize. I just now saw that they had it listed as a detention hearing and not a Form 3 hearing. So
that's not a problem. We'll roll with it. This gives me a chance to tell everyone the Texas Supreme Court and the Texas Court of Criminal Appeals, in compliance with the guidance provided by the Texas Office of Court Administration, have directed all courts in the state of Texas to close their courtrooms except for absolutely essential hearings. That means most of our hearings are not conducted in person, but rather through Zoom video conferencing material. However, in keeping with the spirit of the open courts provision of the Texas Constitution, these hearings are being broadcast live on YouTube, except where otherwise directed by Section 5408 of the Texas Family Code, in which case the court will consider closing the hearing to the public because the privacy interest of the child outweighs the interest of the public in participating in hearings involving children under the age of 14. Any broadcasting or recording of these hearings in any shape, form, or fashion is expressly forbidden by the court. Violation of the court's order may subject you to civil and/or criminal contempt proceedings. Mr. Berger, have you had a chance to talk with Mr. Turner.
Can you hear me?
Yes, sir.
Okay. Judge, I'm pretty sure that we'll be contesting the extradition at this point. He is 17. And I think that's all we could say at this point.
That's appropriate. Then, at this time, based on the information provided to the court, okay, I find that there is at least probable cause to believe that he may be one and the same person wanted by the state of Kansas, that there is probable cause to detain him based on the information provided on that out-of-state warrant for 3 felony offenses, and the court will order your detention at this time. And Mr. Berger, if you will get with the court coordinator and schedule that out-of-state hearing. Now, Mr. Turner, I will let you know, you are now 17 under the laws of the state of Texas. That makes you an adult. It is within my discretion and within Judge Kim's discretion to keep you here at the juvenile detention facility. In order for that to happen, I need you to be on your absolute best behavior while in detention. Have they explained to you the different levels of behavioral levels in detention?
Yes.
Yes?
Yep.
Okay. I need you to get to and maintain level 1.0 consistently. I will tell you right now, you'll probably have your extradition hearing in front of Judge Kim. If you are not level 1.0 at a subsequent detention hearing or at that extradition hearing, it would not be in your best interest because Judge Kim will likely transfer you to the downtown jail. He expects 17-year-olds to be leaders in the back, showing the best behavior. All right? All right, that'll be the order of the court. Thank you, everybody. Thank you, Mr. Berger.
Good morning, Your Honor. My name is Tamisha Parks, and I'm covering for Mr. Mike Jennings.
All right, thank you, Ms. Parks. There's Ms. Uye. All right. Are you Mr. Villa?
Yes, sir.
How are you doing this morning?
Good, sir.
All right, we've met before. My name's Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent, not say anything at all. If there is something you want to say, don't shout it out. Move your hand back and forth like this. That gets my attention. That also gets Miss Rita's attention. I'll create a private internet chat room for you and Ms. Uzuihe to talk about what you want to say. That way she can tell you whether or not you really should say it. Anything you say at this hearing cannot be used against you at an adjudication, disposition, or modification hearing, but it can be used against you at a future detention hearing. Now, Ms. Parks, Mr. Villa is level 1.0 in the back. What other than that, what brings him to court today?
Your Honor, Mr. Villa is here for a 10-day detention hearing. He is also currently pending court, which is scheduled for September the 4th for his motion to modify. He was brought in on July the 21st for a DTA from Arlington Police Department. On June the 25th, his officer received a phone call from his mother stating that Mr. Villa was cursing, high, and threatening her. She called the police. However, he fled before the police officers arrived to home and a DTA was issued. On July the 22nd, at his first initial detention hearing by Judge Kim, he was ordered detained. And also during that, Judge Kim also requested that a CPS emergency report be filed. And Officer Jennings did do that. And to update you on the status of that, the CPS worker is currently out of the office. She's not scheduled back to tomorrow. But according to their notes, Ms. Jones stated she did contact the mother. She provided resource numbers for the community, and she also emailed Santa Fe services. And
All right.
July the 29th, Mr. Vila also was presented before the court again. Their hearing was passed by Judge Terry to schedule a psychological evaluation. That evaluation was scheduled for August the 16th, and currently we are pending the results because it was just the other day.
All right. That report is due next week. Is that correct?
It was scheduled for the 16th.
Okay. Ms. Uzuihe, what are your thoughts? Oh.
Can you hear me, Anna?
Yes, ma'am.
All right, sorry about that. All right, so I did speak with my client. He is doing very well. He is on one outstanding or one no. And I haven't had a chance to speak to mom. I did call her and send a text message to her, so I haven't heard her. But my client did tell me that mom wants him home. And you know, you're not considering the fact that he has done tremendously well in detention. I would ask that he be released, even if he gets released on electronic monitoring. And you know, we're gonna come back to courts whenever he's required to come to court. And also, even if they have a staff meeting, whatever thing that's, you know, that's going to be to his best interest, we're gonna work along it. But yes, we ask that he be released today.
Your Honor?
Yes.
He has a resource staffing schedule for the 28th at 9 a.m. And also he was released on monitor in the past on 2 separate occasions. And on both occasions, he cut it off.
Yeah. Ernesto, we've met before, right?
Yes, sir.
More than once.
Yes, sir.
What am I gonna do?
Like I said.
You need to talk to Mrs. Uzuihe?
Yes, sir.
Okay, make it brief, okay?
Yes, sir.
Okay.
Give me just a second. Okay. Mr. Villa, if you will go use your mouse pad and go down to the bottom of the screen, a pop-up menu should appear on the bottom of the screen. I want you to click breakout room, and then I want you to join breakout room number 1. Can you do that?
Yes, sir.
All right. Do make it brief, okay? Because we got other kids behind you. just want to make a copy of that.
Your Honor, you exited the Zoom, so you might have to do it again.
Okay. Mr. Villa, did you finish talking with Ms. YYYY, or you need me to put you back in there?
I need you to put me back in there because when I went there, it wasn't in there. Like she wasn't in there. It was just me.
Not a problem. Give me just a second.
Thank you.
There it goes. You should have the invitation now. Do make it quick.
I had a question.
Yes, ma'am.
I was also in contact with the lady at CPS, and like they were saying earlier, she had gave me some numbers, and I called, left a voicemail, never heard a response. I really need to get him some help. He really needs help.
Okay.
I mean, this is my son. I care about him. I love him. And I'm doing it just for his own good. But he really needs help. And I've tried so many places. The day that I did call the cops on him, that he escaped from the cops, they told me that they weren't going to help me until he did like something stupid, you know. I mean, there's no use of them helping me once he already done something stupid or they killed him. You know, I'm not saying that I don't want him. I don't want him at home. Like I said, this is my son. I love him and I would never abandon my son for nothing, but he needs help. The other day, I guess one of the nurses from here from Kimball called me and told me that the specialist, like a psychiatrist, was gonna come and check him the next day, and the doctor, and they never came to check him because I never got a call from the doctor. Because he asked me if he was going through depression, if he had angry problems, and I was talking to him and I was telling him a little bit about our lives, and he said he was going to get in contact with Mike the next day, and that the doctor was going to come the next day to check him, and I never heard anything from the doctor.
Ms. Parks, did the psychiatrist or psychologist meet with Mr. Villa on the 16th as scheduled?
Your Honor, I'm gonna have to have Mr. Jennings follow up on those referrals. He's out of the office this week. And
it is my understanding that the doctor did meet with him as scheduled, and that report is due back from the doctor next week. Mr. Villa, you're shaking your head. Did you get to meet with the doctor earlier this week?
Yes, sir.
All right. That did occur. The doctor is in the process of writing the report right now, and the doctor is going to make that report available to Mr. Villa's attorney as well as the prosecutor. Okay. So that's probably why you haven't gotten a call back yet. Excuse me. We're waiting for the doctor to finish the written report. All right. Does that make sense?
Mm-hmm. Yes.
All right.
Okay, Anna, just very quickly, please.
Yes, ma'am.
So I have met with my client, and so what he's saying to the courts is that it is true that he did cut the EM the last time or the other time also, but he has learned his lesson. He said what? He has learned his lesson. He's making a firm promise to the courts that that will not happen again. Your Honor, he's asking for just one more chance, please, that he goes home, that he will never ever, cut his ankle monitor, that he will be, he'll be in compliance.
Can I say something? He's talked to me about that. We've been talking over the phone, and he's been telling me that if he gets released or whatever on the ankle monitor, that he promised not to cut it off this time because he don't want to get into any more trouble. He wants to get over with his probation. So I don't know, you know. It's hard.
Okay, Mr. Villa, do you remember back on April 1st where we had a detention hearing? You remember that?
Yes, sir.
And it was you and me. And at that time, didn't you promise me you
Yes,
weren't
sir.
going to cut off your monitor, that you
Yes,
were going to stay home like you were supposed to? Didn't you make that promise to me then?
Yes, sir.
What happened? You cut it off. All right.
Yes, sir.
Okay. Fool me once, shame on me. Why,
Yeah. Yes, sir.
and that was the second time you cut off your monitor. I can't let you have a third time, right?
Yes, sir.
Yeah, no, I'm sorry. As much as I want to give you a third chance, I don't think you've earned it yet. Okay?
Yes, sir.
I need you to maintain level 1-0. You've been great since the 25th. You've been level 1-0 since the 25th. But this is your third time here. I need you to maintain level 1-0 for 10 more days. Okay? You'll see me again in 2 weeks for another detention hearing. You maintain level 1-0 between now and this, and I mean consistently. You can't dip down to 1A and back up to 1-0. You got to maintain it across the board. And then if you're level 1-0 in 2 weeks, then you'll probably have earned it. Not a promise, but you probably will have, okay?
Okay.
Yes, sir.
All right, but today, based on your history, based on the conversation we had back in April, I can't let you go right now, okay?
Yes, sir.
But keep doing what you're doing. You're doing the right stuff in the back. And that proves to me that you really are committed to this change, okay?
Yes, sir.
Thank you, sir.
All right. Thank you, Anna.
Thank you, Ms. Uwehe. Oops. Yeah, I remember that conversation in April. It's not often I remember the conversation, but I do remember that. All right.
Your Honor, he's going to need an interpreter.
Okay, Mr. Adler, help me out with the correct pronunciation of his name.
Well,
Villa Alba?
Villa Alba.
All right, Mr. Villa Alba. My name is Judge Porter.
Do you want me to interpret or do you want Ms. Guerrero?
Ms. Guerrero, or is Ms. Rodriguez still here? No.
Ms. Rodriguez is out this week, so Ms. Guerrero is covering this judge.
Ms. Guerrero, do you mind helping out?
I nominate Frank, Judge.
Not it.
I'll do it.
All right. Okay, think in English. Okay, my name is Judge Porter.
Jonathan, este es el juez Porter.
This is a detention hearing
Y esto es una audiencia de que usted y yo hablamos cuando te vi en la cárcel atrás.
to determine if you should remain in detention or be released to a parent or guardian.
Y el juez va a hacer la decisión si te quedas en la cárcel o sales con sus padres.
You have the right to remain silent.
Tienes el derecho de no hablar.
Anything you say
Cualquier cosa que digas
cannot be used against you at a disposition or adjudication hearing.
Todo lo que dice en esta audiencia no lo pueden usar contra usted en la otra audiencia que vamos a tener sobre si eres culpable o no culpable.
But it might be used against you at a future detention hearing.
Pero si hablas hoy, lo que dices puede estar usado contra usted si tenemos otra audiencia de detención.
You have the right to an attorney.
Tienes el derecho a un abogado.
Your attorney, Mr. Adler, is here to help you.
Yo soy su abogado y estoy aquí para ayudarte.
All right. Judge Kim has already determined that probable cause exists to detain you.
El juez Kim, la primera audiencia ya encontró que había por lo menos el mínimo evidencia para que estés aquí en la detención.
And your attorney has asked for a detention hearing to be held today.
Y yo, como su abogado, pregunté al juez que si podíamos tener una audiencia hoy para ver si te dejan salir con sus papás.
Ms. Guerrero, Mr. Alba is level 1-0, correct?
Yes, Judge.
And he was brought in on a charge of deadly conduct.
That is correct.
Does he have any prior referrals to the department?
No, sir.
Okay. The deadly conduct alleges 2 rifles and 1 pistol.
Yes, Judge. Of the vehicle that he was a passenger in stated that Jonathan had the camouflage rifle, and according to the victim, while they were at the light, he saw the camouflage gun being pointed at him from the vehicle that allegedly Jonathan was in.
And Ms. Farmer, this is charged as a deadly conduct rather than an aggravated assault. Okay. Yeah, no, I think I know what this is going. Yep. Mr. Adler?
Judge, if it may please the court.
Yes.
There's probably facts that you don't know about. I don't know if I should go into, but these are the alleged facts. My client, though there was 3 guns, but they were legally registered to the owner of the car. So it wasn't like the guns were stolen or anything like that. Jonathan, at our initial detention hearing, Judge Kim asked a lot of questions. I hope I'm not speaking out of turn, and kind of gave me a hint that if we had a plan, a good solid plan, he would consider releasing Jonathan to the parents on the electronic monitor. And that's why I asked for this after 5 days, so he could at least show the court that he's going to be on level 1 and can behave. I think the allegation is strictly this, that Jonathan may have pointed that rifle at the victim. We are going to contest that adamantly. Those facts are going to be in dispute, but separate and apart from the facts, Judge. Both parents are here. They are Mexican nationals. He's never been in trouble before. Both parents told me he's a really, really well-behaved child. He respects the rules at home, and they will bring him to court every time that he's supposed to be in court. He will be on lockdown with them, and they can assure you that he really is a well-behaved young man, that this is way out of character for him.
2 questions. First, has the Mexican consulate been notified?
Judge Kim told us to notify the Mexican consulate, and I emailed them as soon as our first detention hearing, so yes.
Great. Second question. Because they're nationals, Ms. Farmer, is there concern about a flight risk? And Mr. Adler, would you also address that?
Yes, Your Honor. We would ask that he be detained. We would be afraid that he'd be likely to abscond. And also, I mean, a 15-year-old around guns is concerning. So we would ask that he be detained for the safety of the community as well.
All right, Mr. Adler.
Judge, I get the court stance on guns, but truly these guns were not his. He was in the car with guns. I don't dispute that. But to answer your question directly, they have permits, tourist permits to be here until December. They kind of come and go. They have an older son that they stay with in Fort Worth, and that's where they stay at while they're here, who is a citizen. So they can guarantee you that he will come back. They are law abiding. Judge Kim really took to the dad because the dad was agreeing with Judge Kim on a lot of his philosophies regarding guns and kids with guns. I wouldn't have asked for this if we wouldn't have had this plan that Judge Kim hinted at, Your Honor.
Yeah. Let me look at one more thing. Mr. Adler, was the alleged adult companion a relative?
It's a friend that lives on the same street, and maybe Ms. Farmer can correct me. It's my understanding he was also arrested and bonded out.
Okay.
I think.
Mrs. Farmer, your concerns about this case are very appropriate. This is very, very scary. 3 guns in the car, one of them allegedly being pointed at in a possible road rage incident. This could have resulted in somebody getting killed very quickly. And it's also concerning that all of this happened not with the brother present, but with someone who is not a family member. All right. Mr. Adler, would you ask the dad if he will assure the court that he will get Jonathan back to court when he is scheduled?
Señor, ¿entendiste lo que dijo el juez o te lo explico?
¿Qué dijo, por favor?
El juez te está preguntando que si le puede dar la aseguranza que cuando tenemos la próxima corte, que usted personalmente va a estar seguro que está aquí.
Claro, sí, señor.
Sí.
Sí, señor.
Yes, sir.
Es lo que usted nos pida.
Espera, uno a la vez. Por favor.
Are they planning to stay in Texas for the next couple of months? Are they planning to go back to Mexico for the start of school?
¿Ustedes, el plan es quedarte aquí en Texas o es regresar a México para escuela?
Hasta diciembre sí nos podemos quedar.
He said
Hasta
they
que
can
él
stay
esté
here
bien.
until December to take care of this case.
Okay, but what about school?
Pero ¿y la escuela?
Y lo va a hacer por internet.
Okay.
Lo puede hacer por el internet.
He's going to do it virtual, Judge.
All right. Okay. I'm going to authorize his release on the electronic monitor.
El juez lo va a dejar ir, pero se tiene que quedar en la casa con el monitor electrónico. No se pueden ir a México.
No.
Okay?
Está bien.
Yes, Your Honor.
Mr. Adler, if things change, I just have a good feeling about this, Dad. If things change and he needs to go back to school in person in Mexico, then we'll reconsider the electronic monitor at a different time. But there's going to have to be some strong assurances that they'll get back to court when they're supposed to, and that we aren't just continuing because the kid's out of unavailable, right?
Yes, sir.
All right.
Y el juez te dijo que si cambia la situación y necesitan ir a México, que le podemos pedir permiso para que ustedes vayan porque él se siente bien con usted, señor.
Sí, gracias.
Thank you.
Nada.
Pues,
Okay.
Thank you, Judge.
Thank you, Judge.
Thank you, Ms. Guerrero. All right. Please do not bring in any other child or children. Pursuant to Section 5408 of the Texas Family Code, the court is going to close the remaining hearings to the public because the law says when a hearing involves a child under the age of 14, the presumption under our law is that the privacy needs of the child outweigh the public's interest in being part or being able to watch the hearings.
Gracias.
So the court will make that finding at this time, and the court will be stopping the live stream.